Hey everybody, welcome to another episode of Foreclosure Help 777. You can go to my Facebook page, Sue Your Lender, Fight Foreclosure and Mortgage Fraud, and join us if you want some more helpful tips on how to save your home from foreclosure. We're going to talk about what someone has done, and last week a fellow foreclosure fighter filed her complaint in federal court. And we're going to look at that real quick. She's just doing this herself pro se. And you can see she filled out the civil cover sheet and took it to the court. This is what the cover sheet looks like. And you can fill this out. The forms are all online as well, by the way. And this is at the U.S. District Court, Eastern District of Missouri in St. Louis. And you can see the basis of jurisdiction, diversity. Now, if you're not sure what that means, I can tell you real quick about diversity jurisdiction. If you look that up, you can find it online, and basically it says that the district court shall have original jurisdiction of all civil actions where the matter in controversy exceeds the sum or value of $75,000, exclusive of interest and costs, and is between citizens of different states. So let's say that Bank of America is in California and you're suing them in Pennsylvania. Those are different states. Just so you know. And if the amount in controversy is over $75,000, most people's mortgages are over that amount, and if you're suing them for other damages, again, it's going to go over that amount. So the federal court jurisdiction for her seems more appropriate than state court. So let's take a look at what she filed. This is the civil cover sheet. It's pretty self-explanatory. Just fill in check the box. She put in the names of the defendants, which happens to be Midland Mortgage, MidFirst Bank, Broker Solutions, doing business as New American Funding. Different states. She's in Missouri and they're in Oklahoma City, Oklahoma. And basically that's that cover sheet. And then the next thing is a summons. The summons has to be the first thing they see when they open their mail. And it has, you can also get this form at your courthouse, or they can fill it out if you're going to do it in form of papyrus. Sabrina Kohler versus Broker Solutions, Inc. and New American Funding / Midland Mortgage. Summons. You put their address there where it's going to. This one is in Tustin, California. And then it has her address there, and then the clerk of court signs it and dates it. Now when you're in Missouri, they will give that to you when you give them the name of a process server. So she's just waiting on that, but the actual case has been filed, as you can see. They give her a case number, which is right here. You can look it up, 4:23-CV-01332, and this is the format she used. It has to be pretty much the same on every cover sheet. It has to have the name of the plaintiff, the name of the defendant, the docket number, which they have above. For future filings, it'll already be on there, obviously. Now the first opening paragraph. Comes now, plaintiff Sabrina Kohler, unmarried, acting in pro se on behalf of herself, resides at 4023 Fawn Hollow Drive, House Springs, Missouri, and files this verified complaint and action to quiet title. She names herself as the plaintiff and the address that she resides is first thing. And then she identifies the parties, the defendants, New American Funding, and it has their address. Defendant Midland Mortgage, and their address. And then jurisdiction and venue is right here. In Jefferson City, state of Missouri. And then the legal description for the property is right there, right below that. And then the factual allegations. And these are the things that she's stating happened with her loan from the beginning. You want to write it in chronological order. So she's saying that she purchased the property at 4023 Fawn Hollow Drive, House Springs, Missouri, in Jefferson County on November 12, 2019. The amount of the loan was $157,000. A copy of the deed and original loan documents are attached hereto as Exhibit A. And then number 2, it says, plaintiff paid the loan as agreed. Plaintiff was not suffering financial hardship and told defendants they did not need to defer their loan, refinance, or do any loan modification. Number 3, defendants Broker Solutions, doing business as New American Funding, on November 17, 2020, filed a release of deed on the loan number 300-0337-494, which shows this loan was paid in full, attached hereto as Exhibit B. So, you kind of know how this is going to go, right? Just by reading those two things. Number 4. Defendants forged signatures on a note and deed of trust, second set of loan documents, which, according to their records, was signed on October 20th, 2020, in the amount of $154,614. Copies of these loan documents are attached hereto as Exhibit C. Plaintiff alleges that the forged loan documents was prepared to allow the defendants to apply for federal funding related to the COVID-19 pandemic under the CARES Act. Number 6, plaintiff, discovering the fraud, contacted the police department, and a police report was made regarding the fraud. A copy of this report is hereto attached as Exhibit D. Number 7, plaintiff logged into the defendant's New American Funding website to check the balance and found 3 separate loan applications listed. One showed the borrower as Arthur Genuine for the amount of $151,954, dated November 29, 2020. A separate line shows another loan for the amount of $151,954, the borrower Sabrina Kohler, dated September 29, 2020, and another line for the amount of $154,303, dated November 4, 2019. A copy of the website showing these documents is attached hereto as Exhibit E. Okay. Then number 8, plaintiffs, fearing foreclosure, paid on the loan even though they never agreed to the loan's terms and conditions. Payment problems. Now, the next section is going to go over some payment problems that they had with the servicer. The monthly payment was $1,002.64. The payment should be applied as $270.60 to principal, $380.42 for interest, and $351.62 for escrow. Plaintiffs allege that defendant sent monthly mortgage statements that were contradicting, inaccurate, confusing, with unauthorized fees. A copy of the statements showing payment history and a spreadsheet are attached hereto as Exhibit F, as in Frank. Plaintiff alleges that defendant did not properly credit the payments when sent in extra to principal. See statement date April 28, 2021, it shows the next payment is not due until July, meaning the account was paid ahead by 3 months. And then it says, see statement date May 17, 2022, there are fees charged to the plaintiff for the amount of $525 for publication, $1839 for mail, and $2452 for mail. See statement dated March 17, 2022, plaintiff was charged for FC title, which I'm sure means foreclosure title, of $250 and $20 for an inspection. yet she never got an inspection. And then it says, see statement dated April 18, 2022. Plaintiff was charged for an appraisal of $475, foreclosure attorney's fees $412.50, foreclosure title $300, and foreclosure title of $75. See statement dated May 17, 2022. Plaintiff was charged publication of $525, mail at $18.39, and mail at $24.52. See statement dated June 17th. Plaintiff was charged foreclosure title costs $300 on June 9, 2022. Attorney's fees of $361.25 on June 14, 2022. Even though the plaintiff was making payments. The statement dated August 5th, 2022. Plaintiff was charged for foreclosure title costs $300 on June 28, 2022, and foreclosure attorney's fees $1,375 on June 29, 2022. Now, defendants violated both state and federal laws. Now, the Missouri has statutes. All states do. We don't have to go over every little word here. If you want to look these up, you can. But it talks about mortgage fraud and fraudulent transfers. And these are state statutes, not federal. Now, let's talk about the causes of action on her complaint. The FDCPA, the Fair Debt Collection Practices Act, count 1. They violated that. And it goes over what constitutes the FDCPA. If you want to read it, you can, but just to kind of go through this complaint quickly. Debt collectors have to follow certain laws when they collect a debt, and they broke them obviously here. The next section is the False Claims Act. And basically, defendants violated the False Claim Act, which is a federal law that imposes liability on persons and companies who defraud the government programs such as the FHA. It is the main tool utilized by the federal government to combat fraud, and an overwhelming amount of these fraud claims are the result of actions initiated by whistleblowers. Part of this act contains a qui tam provision that allows people with no government affiliation to file actions on the government's behalf, referred to as whistleblowers. So it says here, number 1, plaintiff alleges that if defendants received any government money from the CARES Act, it will be revealed during discovery. That is true. Fraud is count 3. Because plaintiffs never agreed to refinance the loan, and it was procured by fraudulent terms, the defendants are guilty of committing fraud. Plaintiff has employed an expert witness that can testify that the handwriting that defendants used to forge the loan documents are not authentic. They do not match the plaintiff's signature. Unfair or deceptive practices. The UDAP by the Federal Trade Commission makes it unlawful for people to make misleading or false acts to consumers. Basically, it says here, plaintiff was harmed by defendant's action which caused significant harm. The loan was considered deceptive, and the charges to the plaintiff were illegal, unfair, as well as unconscionable. Unfair what they did, obviously, right? Breach of fiduciary duty. We can look this up if you want to read the whole thing to get through this, so this video isn't too long for you guys. I'm just going to kind of go over what she wrote on her complaint. A refinance will reset the loan's length of time and will not benefit the plaintiff, but will end up paying more interest in the long term. Plaintiff was incorrectly charged interest, and principal was not correctly credited, and the remaining principal balance was also wrong. Not to mention all those illegal fees, right? Breach of implied covenant of good faith and fair dealing, count 6. Plaintiff never agreed to getting a refinance, which means defendants violated the implied covenant of good faith and fair dealing. The forged documents are proof that defendants acted in a dishonest manner. unjust enrichment. Count 7. Defendants were unjustly enriched by taking advantage of the plaintiff. The statements and spreadsheet show just some of the harm done to them. Plaintiff anticipates revealing additional amounts of unjust enrichment to be determined during discovery. Infliction of emotional distress. Defendant's actions cause infliction of emotional harm to plaintiff. Plaintiff has suffered and will continue to suffer emotional distress from the constant threat of foreclosure by the defendants. And this is a non-judicial state that she's doing this in, so she's doing this to prevent them from selling her house. Fair Credit Reporting Act, Count 9. The credit score of the plaintiff has suffered as a result of defendant's actions. Now, interestingly enough, she can prove that by attached exhibits. She does have all that information as well that she can give them for later use. Anyway, here's the prayer for relief. Wherefore the plaintiff prays for judgment as follows against all defendants. For an order quieting title to the subject property in the defendant's favor, the plaintiff's favor. For a judicial declaration that the plaintiff is the full legal and beneficial owner of the property. For a determination by the court that the attached notes and deed of trust are invalid. Judgment against defendants as jointly and severely liable for all issues in excess of $1 million. For cost of suit and attorney's fees, actual and statutory damages for violations of the FDCPA pursuant to 15 U.S.C. 1692K and relevant Missouri law, rescission of the entire deed of trust and note amounting to clear title to property as a result of the aforementioned, and damages for the unfair and deceptive acts and practices, and damages in the amount of 3 times the interest paid for such other and further relief as the court may deem just and proper. And then she signed it, dated it, she had it notarized, she had signed a verification form. Gotta do that too, I guess, huh? Had that notarized. Certificate of service, served the other side, also notarized. And then the exhibits we won't go through, but they are there. Guys, this is a good way to protect your house in a non-judicial foreclosure. She also had to file a lis pendens on the same day. So she went to the courthouse first to get her complaint filed. And then she went to the county recorders to file the lis pendens, which, she just wrote the docket number here where it says docket number. And lis pendens looks just like this. It just says, notice of lis pendens. To whom it may concern, notice is hereby given of the commencement of the pendency of a suit in the District Court of the Eastern District of Missouri, blah blah blah. You can pretty much see how this is. It's just basically a notice, and then you have to have a legal description of the property next, and then it's signed. She signed it, notarized it, and handed in with a copy of the complaint to the recorder of deeds, and that will stop them from being able to sell her property. Well, I hope you all found this information useful. If you have any questions, leave them in the comment section, and I hope you'll subscribe and watch my other videos. I'll try to help everyone, as many people as I can. Y'all have a great day.